Supreme Court deals blow to property rights. Chief Justice Roberts, today's decision knocks the definition of private property loose from its foundation. When governments issue regulations that undermine the value of property, bureaucrats don't necessarily have to compensate property holders, the Supreme Court ruled Friday. The court voted 5-3, in Youre v. Wisconsin, a closely watched Fifth Amendment property rights case. The case arose from a dispute over two tiny parcels of land along the St. Croix River in western Wisconsin and morphed into a major property rights case that drew several western states into the debate before the court. Chief Justice John Roberts, in a scathing dissent, wrote that ruling was a significant blow for property rights and would give greater power to government bureaucrats to pass rules that diminish the value of property without having to compensate property owners under the Fourth Amendment's takings clause. Put simply, today's decision knocks the definition of private property loose from its foundation on stable state law rules, Roberts wrote. The ruling compromises the takings clause as a barrier between individuals and the press of the public interest. Donna Youre, in a statement provided by the Pacific Legal Foundation, the libertarian law firm that represented the family in the case, said her family was disappointed by the result. It is our hope that property owners across the country will learn from our experience and not take their property rights for granted, Youre said. Although the outcome was not what we had hoped for, we believe our case will demonstrate the importance of taking a stand and protecting property rights through the court system when necessary. In 2004, Youre and her siblings sought to sell one of two parcels of land that had been in the family for decades. Youre's parents bought the land in the 1960s, built a cabin on one parcel, and left the other parcel undeveloped as a long-term investment. The family attempted to sell the vacant parcel to pay for renovations to the cabin, but were prevented from doing so by regulations restricting the use of land along rivers like the St. Croix approved by the state in the 1980s, long after the purchase of both lots. Those regulations effectively gutted the value of the Youre's property. The property was appraised at $400,000 before the Youres tried to sell it. When the family came to the county, now the only eligible buyer, the county offered $40,000. The Youres filed a lawsuit against the state and county, arguing that they should be compensated for the lost value of the property, arguing the Fifth Amendment of the U.S. Constitution guarantees governments must compensate property owners when land is seized or otherwise made unuseful for public purposes. To avoid liability in the case, the state and county told the Youres they could combine the two parcels of land for regulatory purposes. This meant that even though the two pieces of land were separate and the Youre family paid taxes on them separately, the family would be unable to make a takings claim for one of the two parcels. In short, they could sell both lots together, but not one or the other. Lower courts agreed with the government interpretation and the Supreme Court on Friday upheld the court rulings. Treating the lot in question as a single parcel is legitimate for purposes of this takings inquiry, and this supports the conclusion that no regulatory taking occurred here, Justice Anthony Kennedy wrote in the majority opinion. They have not been deprived of all economically beneficial use of their property. Justices Stephen Breyer, Elena Kagan, Ruth Bader Ginsburg, and Sonia Sotomayor joined Kennedy in the majority opinion, while conservative Justices Clarence Thomas and Samuel Alito joined Chief Justice John Roberts' dissent. The Supreme Court's newest member, Justice Neil Gorsuch, did not participate in the case. The ruling could have implications that go well beyond the 2.5 acres of land in Wisconsin. Several western states filed amicus briefs in the case on behalf of the Youre family, as did the Reason Foundation, which publishes this blog. Though states like Nevada and Arizona did not have a direct interest in the Youre's ability to sell their vacant land, they saw the case as having important implications for conflicts over federal lands. Many state governments own contiguous lots and large bodies of water near areas owned by the federal government, military bases, national parks, etc. If those government bodies are allowed to merge contiguous lots for regulatory purposes, the federal government could impose severe restrictions on state land and wouldn't have to pay consequences, warned Ilya Somin, a professor of law at George Mason University who authored the amicus brief on behalf of those western states. Writing Friday at the Washington Post about the ruling, Soman said it is likely to create confusion and uncertainty going forward. In at least some cases, today's Indeed ruling allows the government to avoid compensating property owners for the taking of their land, merely because they also own the lot next door, he writes. But the vague nature of the test established by the court makes it very hard to figure out exactly when that might happen. With Friday being the 12th anniversary of the infamous decision in Kelo v. New London, in which the Supreme Court upheld an objectionable use of eminent domain, Soman jokes that maybe property rights advocates should hope the court doesn't release any more rulings on June 23. Roberts, in his dissenting opinion, stressed that the court's ruling in Mer could allow for ad hoc, case-specific consideration of takings claims, thus undermining constitutional protections that should be consistent and predictable for property owners. Meaning more leeway for governments to do what Wisconsin did to the MERS. The result is that the government's goals shape the playing field, Roberts wrote, even before the contest over whether the challenged regulation goes too far even gets underway.
Hey Charlotte County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.